get to learning. So hi everyone who's watching. My name is Brandis and I am the program and event coordinator for NEAR. And today we are happy to bring you manuals and margaritas. So if you have a margarita, go for it. I'm going to drink some water because I'm working. And we have John Torvi and Kathleen Sullivan joining us today to present. John Torvi is the Vice President of Marketing and Sales at the Landy Insurance Agency. And he has been in the insurance industry for focusing on the needs of business owners for over 30 years. He holds a bachelor's degree from Providence College and a master's degree from Springfield College, and is a frequent speaker and contributor to professional journals and conferences for the real estate, legal, accounting, and insurance industries. Kathleen Sullivan works in partnership with her husband, Dan, as the owners of Dan Sullivan Realty Group. She previously taught in the Lowell school system for many years. She has earned her master's degree in instructional technology from Lesley College and her doctoral degree in instructional technology and distance education, from Nova Southeastern University. Her continuing involvement in education as committee chair and adjunct faculty for Nova Southeastern University enhances her career as a realtor. She is a visiting associate professor at Realtor University and developed and teaches their capstone course in the Masters of Real Estate program. She's a certified ZipLogix trainer and has served on the education committees of NAR, MAR, and NEAR. So thank you guys both for joining us, and I'll let you guys go ahead and kick it off.
All right. Well, thank you, Brandis, and hello, everyone. Appreciate you joining us today. And you'll see my blue sky background. That's Big Bend, Texas, out near El Paso, because it's such a gray and miserable day here in the New England area. I thought I'd bring a little sunshine in. I am so pleased to be able to present this webinar today with Kathleen, whose credentials and experience and success speaks for itself. And I really appreciate her taking the time today, not only to join us and do the preparation, but be able to provide the expertise that she has for all of you listening and tuning in. So it's always been my contention, being on the risk management on the insurance side, that the independent contractor agreement was never enough in terms of a formal understanding between brokers and agents. And I think the problems that we see on the insurance side and on the claim side justify my concerns. And therefore, that's why we have this presentation today with some objectives that you can see up there. Understanding what liabilities the broker incurs when they're managing an agent or agents. Where are the shortcomings in the traditional or the standard independent contractor agreement, and how might those be supplemented with an additional policy and procedure manual? What's all covered on this from the insurance perspective, and what's not covered? And Kathleen, I think, will also add a lot to this last section here about, how do you actually create it? What do you want to put into it? So we're going to have a dialogue, Kathleen and I. We welcome your questions. And we will save the questions till the end, if that's okay. And we're going to go right till about 4 o'clock today. So let's start with the insurance part of it, which again drove my concern here. Typically, real estate firms will have two types of liability insurance. One is the errors and omissions coverage, which covers their professional services, the obligations that you have as a professional, ethically, contractually, and so on. And then your general liability policy covers things like a person slipping and falling at an open house, or property damage to a home that you're showing or listing, and so on. So we have these two policies, and they all intersect, and they all have big gaps in them when it comes to protecting issues and disputes between brokers and agents. In order for any of the insurance parts of it to work, there has to be a understanding on the part of the agent and broker that anything that the agent does has to be with the explicit permission of the broker owner, or what we're technically going to call the named insured here. In other words, if a broker does not give permission for an agent to perform a certain service or to do something, sign a contract, take a listing, do a property management service, whatever that might be. In fact, the insurance can become null and void, leaving everybody in a big hole with no coverage, no protection, and a lot of at the least animosity between the broker and agent, and at worst, monetary issues around commissions and damages and liabilities and so on. So we really want to avoid that, because that's a huge mess that insurance is really not going to solve for you. Some of the things that we'll talk about, especially Kathleen will address some of this around the marketing and other compliance issues that need to be addressed and put in writing. We're going to advocate for that. You'll hear me say it, and I think Kathleen say it a lot today, that it's got to be in writing. It has to be there and documented so everyone can understand it and agree to it. And if in fact there's a dispute, you have a solid piece of a contract and agreement to go back to. So no agreement, no insurance. How about that? We'll just summarize it up like that. So what are some of the potential gaps, more specifically in coverage? Well, commission disputes. And when I talk about what the gaps are, these should be light bulbs going off. I hope they're light bulbs going off for everyone that says, this is something we need to put in writing. And this is an understanding and agreement that we need to have between agents and brokers in our firm. So everything that's a gap should also be a light bulb that says, hey, we need to include this in our agreements, in our manuals. So commission disputes are not covered by any insurance. Certainly anything related to fraud would not be covered in any insurance. And, we do see examples of collusions between the agents and the lenders and the appraisers and the other agent and the property owners. Unfortunately, that happens. I think there's a higher risk of it now with escalating prices and bidding wars. We'll address that in a little bit. But certainly that's nothing that's covered in any form in any insurance. What about things related to employee or agency agent dishonesty and embezzlement? We do see that in real estate firms. It can take a lot of different forms, but something certainly to be aware of and to address in a policy manual as well. These are the things that these last couple of bullet points here, these last three are ones that are very, very practical and real for me, because I get calls on these all the time. Get a call from an agent that says, I want to do this and my broker won't let me. Can you get me insurance? Well, we know that they can't act as a licensed real estate agent if they're not hanging their shingle or themselves, so to speak, under the shingle of a broker owner. So no, you can't do those things. But what happens if the agent goes rogue anyway and performs services that are not approved by the broker owner and the named insured? Okay. These are things that clearly need to be listed in the policy and procedure manual. We'll talk a little bit more about that as we go on. And unfortunately, all of us are people. We're salespeople. We like conversing. We like to be helpful. Sometimes too badly, we want the sale, and we're willing to take a leap of faith, so to speak, where we answer questions, provide information that is outside of our authority and our legal purview. We do see situations related to unauthorized tax or unauthorized legal advice. There are ways to manage that as a broker to help your agents not cross that line, because again, that's another thing that you're probably not going to see covered in insurance. And those things can also lead to a legal or civil sanction as well. So Kathleen, we talked a lot about this, don't leave home without the procedure manual, that ICA is really not enough. Can you talk a little bit about how they might differ?
Well, the independent contractor agreement is for one person. You do that with your individual agents, and it's specific for that agent. It spells out, what you're supposed to do, what the relationship would be with the broker, what type of commission splits it'd be. Definitely say that the broker sets the commission rate, not the agent. The agent can't go in and say, well, I like you, and so I'm going to give you a lower rate than the company says. Everything has to be done by the broker for those things. It has to be in writing. It has to be signed. But on a practical note, for the ICA, I really think that the brokers need to sit down with the agents that they hire and go over each article in the agreement. Now, we use the mass one from MAR in our company. We're small, and that does make a difference. And we will sit down and go over things and explain it and give examples of how somebody could go wrong or what they should do, how things should be done correctly. And, follow the laws. I mean, there are federal statutes you have to follow in these things, and mass general laws as well. Now, the manual is more specific to the company, and it gives you a lot more guidelines. It definitely, again, it spells out the relationship between the broker and the agent. It explains that the agent doesn't own the listing. It's the broker, it's the company's listing. So it isn't their particular, even though their name will be on it, but the company name is on it too. And I think that's important for them to understand. It spells out the duties, the things that they are responsible for, the things they're not responsible for, the things the broker is responsible for. Like, we don't provide, you're an independent contractor. We don't provide medical insurance. We don't provide workman's compensation. There are things we do provide. If you want office space, yeah, you can have a desk, you can have a spot in the office, you can have access to forms and certain supplies. Personally, we buy business cards, we do, a few extra things like that. But we, by the same token, we don't mandate when you have to work. If you say, yeah, I'm going away for 2 weeks and you're an agent, that's your purview. You're the agent, you're the independent contractor. If you choose to do that, you can. It's important. You have to go over all the different laws, the agency, that should be in there, all the different forms of agency. Go over it. It can get confusing. And it's something that, again, everything is written in legalese. You need to break it down, sit down with people, talk, give examples, and just be very clear about how things should be. Professionalism needs to be in there, in my opinion. It's in ours. We expect people to look, dress, and act in a professional manner. I don't want someone from my company going out in an old t-shirt and jeans to show property or to go to a listing agreement. I think it's important. It reflects on the company. If you look professional, people treat you as a professional. I think you need to be sure that they are fully equipped with what they need. So if you're going to go to a listing, fine, go. But don't go say, oh, well, I'm not sure. Go over things with an agent, especially when they're new. Go over everything first. And very often, we've started new agents, either Dan or I will go with them. We don't interfere, but we're there just in case they get hung up on something. But things like that are important. And you can put that in the manual when you're writing your own manual. You can say, on your first 3 appointments, you will be accompanied. You will have a mentor that will be there with you. You have to go over what safety things are. You're not going to go out on an appointment and go into a house with someone you don't know. There are safety rules, safety things you can go, and you can add all of these things. One thing you do have to have is an internet policy agreement. And it goes in and explains about passwords and safety and a lot of things like that. But you also have to deal with social media and explain how somebody's personal social media will reflect on them. And everyone checks social media. Employers check social media, clients check social media. They want to know who they're dealing with. And it can be detrimental. I have seen posts from professionals in real estate and say, oh my God, I cannot believe they put that online, because it reflects on them. And you have to adhere to all the rules, all the regulations. I think it's important to be on a friendly basis with your agents, but be sure that they are aware that you're not their new best friend, that you are the head of the company, and what they do reflects on you and it matters.
Kathleen, there's an awful lot here. If I could jump in for a moment.
Sure.
I mean, those points are just, so important. And there's a couple I'd like to just take another moment to discuss if we could.
Sure.
The comments and the expectations around professionalism, which has to, in your comments, you mentioned a professional demeanor and a professional dress, so to speak, and social media. These can be traps also for brokers, because you have to be very careful that you're not crossing any lines that can be deemed too personal or even considered to be discriminatory.
Yes.
I live in Rhode Island. A lot of people know that we had a situation here in our state legislature where they had to make rules or discuss their rules in the legislature about whether or not a man could come in a sweatshirt, because he was representing, the working class folks in his district. And they kind of said, well, no, that's not professional. And we had this whole discussion in the state about what's professional demeanor. So you have to be really careful to create this expectation, but not, appear to be in any way discriminatory or prohibitive or cross any lines. And with that in mind, I'll make a very general statement right now that whatever it goes into this policy and procedure manual, have it reviewed by an attorney. Recognize that you're creating a contract. You want to make sure that in addition to this, the basic expectations like, no, you can't do property management, you're also not violating any tenants or restrictions, qualifications that might impact independent contractor status, for example. And you also want to make sure that you're not creating any framework, guidelines, or expectations that, again, can be seen as impinging upon a person's rights and freedoms. So, Kathleen, those are great points. And I really like that you mentioned realtor safety also, because, frankly, I kind of forgot about that one. But, what are the standards for an open house? Because is a broker liable if an agent does something, goes to a showing, goes to an open house or a meeting on their own and becomes physically in danger? What's the broker's liability for that? So that was a great point that you mentioned, and certainly something that should be addressed in the manual as well. I want to touch on a couple of things that Kathleen and I talked about also in preparation for this. One of the big hassles we see all the time is after there's a claim, the agent and the broker are arguing about who pays the deductible. Okay. So that's something you'd like. I know, Kathleen, you mentioned, desk fees and marketing fees and so on and so forth. That should include the cost of any insurance that's being passed on to the agent, as well as what the responsibility for the deductible is, if in fact the agent is responsible for a claim. Ultimately, the deductible needs to be paid by the broker owner, the named insured. But what's the agent's load on that, if at all. I mean, that there's no rule, so to speak. A broker can create any kind of scenario that they want for this, but it does need to be in writing at the beginning.
Yeah.
You don't want to have that argument when the
Yes.
lawyers are, knocking at your door.
And wouldn't it depend on how egregious the offense was? I would assume that most times the broker is responsible for their agent's conduct.
Always. That not only from an insurance perspective, but I think it's pretty clear that Massachusetts law, and I think this is universal around the country, says that the broker is responsible for the agent's conduct. And I think that's why we have this model where all the states require an agent to be working under a licensed broker.
Mhm.
So the other thing we talked about, Kathleen, was courtesy showings.
Yes.
And I know that that's not a phrase that a lot of people are familiar with. Again, except unless you're at my end where we see the problems. A courtesy showing is when Kathleen's company, Sullivan Real Estate, has a listing and they're going to do an open house, for example, or even a showing. But Kathleen and Dan can't make it, and neither can their agent. Something came up, and they call me at John's Real Estate, totally unaffiliated company, and say, but friends, hey John, we can't manage this open house on Sunday afternoon. Can you sit in for us? And I say, sure. You guys are my favorite people. Of course, I want to come in. You buy me a beer the next time we get together. Or in this case, a margarita, right? What are the problems with that? Well, unfortunately, there's a couple of problems. When Sullivan Real Estate, if you don't mind, Kathleen,
I don't mind.
An example. If Sullivan takes a listing and starts doing showings and has an open house, they have legal care, custody, and control of that property. And that's a big implication. And you can kind of guess what the implications are once you have care, custody, and control of a property. Everything from the safety of the people that enter it to the security of the property and its possessions. And the insurance contract, which is supported by law, and it states that in order for the insurance to apply, you need to maintain care, custody, and control of the property. Once Kathleen lets me handle the open house as an unaffiliated party to Sullivan Real Estate, guess what? They've relinquished their care, custody, and control. So legally, they are still responsible, but they have no insurance protection. I have no insurance protection because I have no affiliation with Sullivan Real Estate, nor does my firm have the listing. So if you get into a situation where you may not be able to make your appointment, might not be able to make your showing, might not be able to man the open house, someone else from your firm needs to do that in order for you to have legal protection and insurance protection under that. And so that's something that I think can go in a procedure manual too, that as an agent, you just can't say, I can't make it. My daughter has a basketball game. Kathleen, can you fill in for me?
Yeah, and I think it's particularly difficult for small companies. Sometimes an open house or a showing would probably have to be canceled because you don't have a lot of agents. You don't have the flexibility that a large franchise would have.
Yeah, it's true. It's a trap. It's one of those things you have to watch out for. But we see enough of it to make sure that we wanted to note it today. So thanks, Kathleen, on that.
All right, and disclosure. This is another one that can be, I think, a real trap for agents. There are things you don't legally that you don't have to disclose unless you're asked. If someone has been murdered in the house, or there's a suicide or particular illnesses, you don't have to disclose that unless somebody asks you. You have to be honest, and you can get caught in a nice little trap if you lie about it. It's definitely, if there's, say you have a listing and you get an offer, it's an accepted offer, and the person does a home inspection, the potential buyer, and find the home inspector says there's possibly structural damage, let's say the supports in the cellar aren't strong enough, and the buyer backs out. That has to be disclosed to future potential buyers. You cannot hide something like that. You have to let them know. And I think that in itself can be a threat, because not everyone, if you know for a fact that there's asbestos, that's something you got to disclose. Things like that's a safety issue, you know. But and that would things like that come up in every home inspection, and very often when you see, you know, back on market, it isn't always financing. Sometimes it is because things that are wrong with the house, and the seller isn't going to fix them. The buyer's going to say, well, forget it, I don't want to go in. But once that listing agent knows what's wrong and it has been inspected and they know for sure it's wrong, they have to disclose that, even if the seller doesn't want them to. They're legally bound to. And fair housing, I think that is probably particularly tricky right now. There's federal laws and there's state laws, and the state laws are actually even more demanding, I guess you could say, than the federal laws. I mean, you cannot discriminate, you know, sex, race, religion. Oh, I mean, there's a ton of them. Family status, number of children in a family, whether somebody, for rentals, if someone's Section 8, you can't say, oh, I'm not going to do that. It's rentals can be actually pretty tricky when it comes to something like that. But you have to be very careful when you advertise, that your advertising isn't discriminating. Lovely, quiet neighborhood for a retired couple. Can't do that.
Mm-hmm.
Oh, that's just basically saying, if you're young and have children, or if you're young, don't even bother coming. It's discriminatory. And you do see that. You see people say, oh, wonderful family area, you know, wonderful schools. You know, you might want to say, as an agent, lots of times I will say, because I taught for so long, oh, this is a good school system, but it's not in writing, it's in conversation. I'll say, yeah, it's a good school system. I've heard agents give building advice. This would be great, just knock down that wall. Not a contractor. If you don't have a contractor's license, don't give that advice. Say, it would be lovely to knock down that wall, but you'd have to talk to a contractor. It's the same as giving legal advice. You cannot give building advice. As far as HIPAA, I don't, you're not going to reveal if somebody has a disease. I mean, it's not really your business in the first place. And some things you just don't want to know as an agent.
Well, a lot of that's related to COVID too, Kathleen.
Yeah. Well, yes. Has that even been tested legally?
No. Yes, it is being tested now. It is, and I think we'll see more of it once some of the eviction moratoriums and so on, and you know, and that's a part of the stigmatized properties. You know, if somebody dies, if there was a crime that was committed, you know, all of those things. You know, an additional piece of caution too is that, especially I think with near members being so close to the New Hampshire or Maine borders, you may do work in multiple states. So it's important to understand and know what the disclosure laws are in other states too, if you're licensed and working in other states besides Massachusetts. Disclosure easily accounts for half of all claims that we receive. So it's a big deal. And I think Massachusetts agents, frankly, are at a disadvantage that the law doesn't protect them better. And in fact, even protect the sellers a little bit better. It seems like it's a great thing. Oh, I don't have to disclose, but I think it really puts real estate professionals at a disadvantage because there's no real guideline to follow.
Yeah.
So it puts a lot of weight and responsibility back on the individual agent or broker to figure out what to do with any property. You know, your point about disclosing and not diagnosing, words right out of my mouth. And Brandis, I know, has heard me say this so many times before in different webinars. You disclose, that there's a leaky roof or a cracked foundation or whatever it is that you know about the property, but you sure as heck don't talk about how to fix it, or even why the roof leaks. In writing, you put it, to the prospective buyer that we're aware that there's a defect in this property. We recommend that you hire a home inspector, a structural engineer, or a roof expert, whatever it is, to determine the severity of the problem, whatever remediation is necessary, and definitely don't put a dollar value. Well, it'll cost you only about $1,000 to fix that roof. Definitely don't do any of those things. Disclose it, leave it up to the experts in writing to do the rest of the work.
One other thing that I think it's important that brokers do is check the listings that their agents get to make sure the information they're putting in there is correct, because it is not always correct. And they need to check. I mean, you can't say that, oh, well, there's no wetlands in this area, or you could build behind it, unless you absolutely know. You can't say there's conservation land when there necessarily isn't. That could get that company into quite a bit of trouble, I would think, from the person who bought the house and said, oh, nobody can build behind me, it's conservation land. And then, a month later, a house starts to go up. And you have to check to make sure any information that your agent puts down in a listing is correct.
Yeah. And all of that can be defined, going back to our original topic here, in a procedure manual about how your agency handles disclosure, and what forms, cover letters, templates it has for an agent to use to explain disclosure, recommend, follow up, and so on. Those can certainly all be part of that manual. Kathleen, you talked about marketing a little bit. Do you want to circle back on that?
Yes, there are very specific rules for marketing on the internet. If you did print marketing, the name, you have to put these things. You can't just throw up on Facebook, oh, this great house is for sale, my listing, and nothing else. You have to have all the information in there. Other than that, it's not legal. And the other thing that is mentioned here that I want to touch on is intellectual property. Have you ever looked at the pictures on MLS Pen and you think, they're kind of fuzzy looking. They're not real clear. Very often they're copied pictures from a previous listing of the same property. That is copyright infringement. You can't do that. You can't take wording from somebody else's listing and put it in yours. It's illegal. And I don't think a lot of people realize that that's stealing. Basically, it's just plain stealing somebody else's work. So you either take your own pictures or hire someone to do it. Do your own writing. Yeah, you can look at other ones. You can get ideas, but you cannot copy someone else's wording or photographs and use it as a publication.
Brokerages have intellectual property also. So what needs to be addressed in the manual is also what happens when an agent leaves the firm. What information are they entitled to take with them? What is considered proprietary and solely the property of the brokerage? Who gets to take a listing with them or not? Who owns the marketing pieces? Those things, some of those are covered, I think, in the ICA, but I think it goes much further than that. Because now you mentioned websites earlier and other types of digital property that's out there. Social media property, who owns that? Okay. So in order to address that, put it in the manual. And, Kathleen, way back when you talked about non-compliance.
Yes.
So before we get to the last couple of bullet points here, maybe we should go back and talk about, what a broker needs to, and how they need to address non-compliance.
if you are going to address this, everything has to be done in writing. It has to be kept in a separate file for each agent, and it has to be done systematically. Otherwise, they can come back against you and say, I didn't know, you didn't tell me. You never had that meeting with me. You have to document everything. Usually what it is, first time someone does something, an agent does something, I mean, unless it's something horrible. Did wrong, but document you had the meeting and ask the person that you're having the meeting with just to sign a little form that says, yes, we discussed such and such a thing on such and such a date, and I understand my mistake. What happens the second time, you do a more formal written evaluation. You again talk to them and warn them they are in danger of termination if they continue. Third time, document, signing, and then it is termination after that. But you have the backup file saying, I told them this was wrong. I did it again and did it more completely and had a complete written agreement on this. And then the third time, we have an improvement plan for them. We had them, and this is, they still did made the same mistake, so therefore I do not want them in my employ, or I do not want them in my brokerage. And it does happen. I mean, not so much with a small one, but with larger companies. Somebody calls and asks, oh, can I speak with Joe, please? He's my agent. Oh, Joe's not here, but I can help you. You don't do that. That's taking someone else's client. That's definitely not how you play the game in real estate. Things like that should be written up, and eventually people can be terminated for it.
You mentioned a couple of things in employment law. Just because the agents are independent contractors, it does not take away the broker owner's obligation to provide a fair, equitable, and safe workplace. So you mentioned discrimination and harassment. Yeah. All of those things need to be addressed in the manual. That you can't. What are the tolerances for race, gender, sexual discrimination? What are the tolerances for sexual harassment? What are the tolerances for any other type of behavior that you might expect in an employment setting? The independent contractor status doesn't negate any of that.
And favoritism.
You can't.
If the broker gets a call and wants to hand it off, you can't hand it off to the same agent all the time. You have to do it fairly and evenly.
Right. That would be considered wage discrimination, as well as creating unequal opportunity, all of which can result in lawsuits and have proven very difficult for the broker to defend and win. So anything related to employment practices around these issues should clearly be stated. And it's a good idea to pull those out maybe once a year at your annual team meeting or whatever you might do to remind everybody of employment practice standards.
And I think it's important to go over these things. If you're not, because you can't mandate that someone goes to a meeting, but if you have individual meetings, you can do it then. And if you have any question about an agent, do it more than once. Bring it out a couple of times. Don't say, hey, let's just go over this. Let's just be clear on this. And do it in a non-threatening way. Like, I just want to make sure that we're all on the same page. And it also establishes a nice culture for the company. My broker's there for me.
Right. Because ultimately the broker is going to pay the price. Mm-hmm. The offending party may get fired or terminated, lose their contract with the brokerage, but the broker is the one who's going to have to pay whatever fine, penalty, and liability there is to the party who has been offended. So this is a big deal. Last thing on this page, Kathleen, we talked about notification of claims.
Yes.
I can envision a scenario where an agent receives a notice from an attorney or a disgruntled client about dissatisfaction with the deal, with the transaction. and they don't notify the broker owner. Okay. There's a lot of negative consequences for that. Because let's start with the insurance. The insurance policy mandates that the insurance company be notified of a claim or a potential claim as soon as possible, or as soon as the party becomes aware of it. So you don't want to jeopardize your insurance.
No.
And we know that anytime a lay person tries to take on an attorney who's representing a disgruntled party, is only going to make it worse.
Yeah.
Okay. So you want to, try to keep these matters small and contained as possible. In other words, you're paying for insurance, let your insurance company handle the legal matter. Okay.
Even if there's, my thoughts are, even if you think there might be a problem, call the insurance company and say, hey, look, this might happen. We don't have any notification yet, but there is a possibility there will be some. So just heads up.
Right. It's very important that that's done. Keep the problem from getting out of control. So how about some questions? Brandis, do we have any questions out there?
We did have one, actually. It says, if a home is back on the market and I ask the listing broker, quote, what is the reason for the deal falling apart? Does the listing broker have to disclose?
No, they don't unless it's a structural issue.
Okay, that was the only one.
Yeah, lots of times they will. I actually sold a condo that had fallen apart 3 times. And I did say to the listing broker, I know you don't have to tell me, but this is just a little suspicious. And it was just 3 very odd reasons, and it had nothing structural or anything else to do with it, but they can tell you, they don't have to.
Okay. So you can ask and maybe get an answer.
Yeah.
Awesome. That was the only question. Unless anybody has any now that they want to throw in the question box for us. I don't think so. You guys covered a lot of good stuff.
Okay. Well, thank you so much, Kathleen. That was just great information.
Oh, thank you, John, for asking me.
Yeah. Well, thanks for everybody who tuned in or will tune in. I believe this is going to be posted on the website. So if you do have questions about any of this, I know I'm happy to answer any questions, and I'm sure Kathleen is available. Such a well-known figure up there in the Northeast Association of Realtor Land. So please reach out to us, and otherwise, thanks so much. I hope this was helpful for you. It sounds like a lot of work, probably is, but will save you a lot of hassle down the road. So have a great day, everyone, and thanks again.